Good evening and a very warm welcome to your platform on NewsX. Speak Out India, I'm Akshay Tandon. There is some hope in sight for impending justice for Damini. The outcry India displayed on lowering the age of juveniles or having exceptions looking at the gravity of crime seems to have been heard. The Supreme Court has issued a notice to the Union government asking the centre to reply on Damini's parents' plea on the juvenile convict who was the most brutal be tried under the criminal code and not under the juvenile laws.
एक जुवेनाइल जो जुवेनाइल नहीं है उसको मान लिया गया कि नहीं जुवेनाइल है 37 आधार पर माना गया हो उसको सजा की बजाय उसको सुधार गृह में रहकर उसको सजा में मजा में बदल दिया गया है.
For close to a year they have fought for the justice for their daughter so cruelly snatched away from them. Galvanized by nation's support, they have demanded to know why someone who's old enough to rape and kill is not termed old enough to pay for it. But in perhaps Damini's last hope at justice, the Supreme Court has taken up a fight asking the centre to respond in 4 weeks on their petition as to why a blanket cover should be given to all juveniles irrespective of their offence.
तक जैसे निर्भया के केस में हुआ सिर्फ 3 साल मैक्सिमम सजा हुई और वो भी रेफॉर्मेशन होम में. उससे कोई भी एक मैसेज नहीं जाता, उससे कोई भी किसी प्रकार से जो ना विक्टिम को रिलीफ मिलता है ना समाज को एक मैसेज जाता है ना कोई जो पोटेंशियल ऑफेंडर होता है उसको जाता है. तो इसलिए हमारे को कानून में ये जरूर देखना पड़ेगा कि विक्टिम फ्रेंडली हमारा कानून हो और विक्टिम की तरफ से देखा जाए कि अगर गुनाह घिनौना है तो सजा भी उस प्रकार से होनी चाहिए. उस प्रकार से बचावने की जो एक दृष्टि है वो नहीं सोचनी चाहिए.
The Supreme Court's decision bringing cheer to everyone campaigning for this cause.
The Supreme Court has rightly issued a notice to the central government as well as Delhi government as to why exception should not be made, that protection of Juvenile Justice Act should not be given to minors who are involved in serious offences like murder and rape.
मुझे लगता है ये एक वेलकम मूव है सुप्रीम कोर्ट का, क्योंकि ये ऑलरेडी पब्लिक डोमेन में एक डिबेट चल रहा है कि अगर 16 साल से ऊपर की उम्र के लोग हीनियस क्राइम्स में कर रहे हैं तो उनको एज पर लॉ जो वहाँ एडल्ट्स डील होते हैं वैसे डील किया.
Even if the Supreme Court's action does lead to Parliament amending the law, it will not bring justice to Damini because the amendment cannot be applied retrospectively. But when it comes to parents of Damini, they say that they will continue their fight for justice.
But even if Damini's parents do not get justice for their daughter, they can seek solace from the fact that their crusade may end up making the lives of millions of other Daminis safe across the nation. With Sumit Nagpal in New Delhi, Bureau Report, NewsX.
And in this edition of Speak Out India, the question we ask you tonight, is the Supreme Court notice indicative of immediate change required in the juvenile laws in our country? Our telephone lines are now open. The questions and the numbers flashing on your screens, 01204369942. Go ahead and speak your mind out tonight. To take this story forward, joining me at the moment is my panel, Mr. Sanjay Hegde, advocate on the Supreme Court. I have Ms. Vasundhara Pathak Masoodi, advocate again. And I also have with me Mr. Amod Kant, former chairperson of the DCPCR. Gentlemen and ladies, before I come to you, a quick check with our viewers. Kailash joining us from Mumbai. Sandeep Thakur from Thane. Sandeep, please stay with me. Kailash, kindly go ahead. Speak your mind out. Okay, we seem to have lost Kailash for the time being. Sandeep Thakur, kindly go ahead. Express yourself.
Sure. Yes, there is a need to change the law. But please, everybody needs to keep it in mind that the accused age should be reduced to 16. Not everybody. Because the victims are also 16, below 18, and they get the protection of the PETA and all the laws where the minors are protected. So please keep it in mind, the accused age needs to be reduced from 18 to 16, not for the girl victims, you know. If they do it blanketly, it will affect a lot of other laws, which is not advisable. Only for accused, the age should be from 18 to 16, not for victims.
Okay, all right. Thank you very much indeed for Sandeep making that point. Ms. Ushara from Bangalore, please go ahead, ma'am. Express yourself.
Well, the time has definitely come. But too when he has committed such a heinous crime. In countries like US and UK, where when a juvenile commits a serious crime like murder and rape,
yes,
the case is shifted to adult court. In fact, in some states in the US, kids as young as 10 years can be tried as adults, you know. And even the United Nations rules for juvenile justice states that punishment even for juvenile shall be in proportion to circumstances and gravity of offence. And here in India, in the recent cases like the Nirbhaya case, the Shakti Mills case in Mumbai, and even the Guwahati rape case have all been cases where minors were involved. So when a person is mature enough to commit murder and rape, then he is mature enough to undergo punishment commensurate to the crime committed.
Okay, I'm going to take that up in just a bit. Rajpal from Bombay, kindly go ahead.
See, Akshay, Supreme Court has very rightly given notice to the government because even the Supreme Court is taking it very seriously that the punishment, because the punishment should be proportional to the crime they are committing, whereas they may be juveniles. A man who is juvenile committing such a ghastly crime, knowing the consequences, what he is doing, he is committing rape, he should know, and they are causing the death of the woman by their other acts.
So it calls for an immediate change is what you're saying, Rajpal, right? Thank you very much indeed. Sudhir Pandey, stay with me. I'll come to you. Before that, let me go across to Mr. Hegde. Mr. Hegde, what do you think this is indicative of when the Supreme Court has asked the Centre to reply on what Damini's parents have sought for justice in terms of the juvenile in this particular story?
Look, the Supreme Court had already issued notice in an earlier petition filed by Subramaniam Swamy. So therefore, when a second petition comes up, it is but natural that the Supreme Court says, okay, we'll hear one more point of view, which is from the parents of the victim themselves. I would not put in any further meaning into just issuance of a notice. All issuance of a notice only means that the Supreme Court is will be considering the question after receiving any inputs if the government so desires. And I've seen in the newspapers today that the government itself is thinking of a change in the law. Now, any change in the law, as your correspondent Sumit Nagpal rightly pointed out, can only be prospective. On the facts of this particular case, because of the constitutional protection against ex post facto criminalization, it cannot be applied. But when has the time come to change the law? That is for the legislature to decide.
Okay, Ms. Masoodi, your thoughts on what the Supreme Court has done today while it sent that notice? Is it indicative of a change that will be brought about? As Mr. Hegde is saying, it's just a notice and we should not be reading further into it.
Absolutely. As Mr. Hegde said, I would like to add to it that we should not infer many meanings with regard to issuance of the notice, but one thing is categorically clear, that if a law suffers defilement and it's incapable to commensurate the the offence which is committed, then it becomes very important to revisit the law. And I believe that no matter what comes, but in any way, there won't be any retrospective effect on the the pronouncement of the verdict which has already been given with regard to that juvenile.
Okay, let me go across to a few people on that note. Sudhir Pandey from Mumbai, Kailash also from Mumbai. Kailash, please stay with me. Sudhir Pandey, kindly go ahead, express yourself.
Yes, what I would like to say is this, I don't know whether it's another realm of Supreme Court to reduce the age for juvenile punishment, because I think the rule will have to be passed in the parliament. But I think there is a need of the hour, because the way, children are exposed to the media and all that, and their hormonal changes or something, they get more matured, earlier than 18 years. So if they do this sort of heinous crime, it's a good decision to reduce the age from 18 to 16 for punishment.
All right, thank you very much indeed for calling in. Sudhir, Kailash joining us from Mumbai. Speak your mind out tonight.
Okay, Akshay, I just don't understand why the law cannot be amended retrospectively. Remember the Vodafone case? It was it is amended respectively. See, with the need of the society, the laws are made based on the need of the society and the crimes which are committed. So nothing is impossible. Everything is possible.
Okay.
So sitting in the parliament, people, MPs, MLAs, elected by people.
Okay, well, let's get a quick let's get a quick response on what you are saying, Kailash. Mr. Hegde would like to respond to you.
Retrospective legislation is possible in taxation cases, but not in criminal cases. Now, if you allow retrospective legislation as far as criminal cases are concerned, today it is not a crime to wear a black coat. Tomorrow a government can say anybody who wore a black coat on the night of December the 1st, 2013 is a criminal. So that's the point. We have a constitutional protection against making criminal that which is not criminal. Criminal law has to be very specific, saying this is the law, if you break it, you will go to prison. So those things cannot are constitutionally protected against retrospective legislation.
One more thing I would like to say with regard to this particular question, yes, that a person who has already been tried and convicted cannot be tried and convicted for the second time for the same offence.
So you're saying in fact there will not be justice per se for this particular convict in the Damini case?
There cannot be any retrospective decision or application of law.
Okay, let me go across to two callers on that note. We have Prakash Rai from Madhya Pradesh and Rajiv from Noida. Rajiv, please stay with me. Prakash Rai, kindly go ahead. Express yourself. Okay, we've lost Prakash for the time being. Rajiv Sinha from Noida, please go ahead.
Yeah, very good evening.
Good evening, sir.
The thing that this law should be amended, that is okay, fine. But after the Damini case, there was another law, that is Indecent Representation of Women Prohibition Act, that was also amended and that was passed by the cabinet. But it has not come in the parliament to be implemented. There are lawyers on the panel, and please ask the lawyer when that law is coming, and please ask Mrs. Krishna Peter when that is being made into law. The Indecent Representation of Women Prohibition Act Amendment Act.
Okay, Rajiv, we'll take that up in just a bit. Before that, V. Srinivas from Bangalore, please go ahead, sir. Express yourself.
Good evening, sir.
Good evening, sir.
I am wondering why public hanging should not be carried out in these cases, sir, and actually telecast live, so that the message goes strong and clear,
lynch mob
that nobody can escape. That nobody can escape punishment.
That's taking law in your own hands. Well, we'll delve in that also in just a bit. Thank you very much indeed. Would you like to respond to the caller before that, Rajiv, who just called in?
No, all I would like to say is that really, please, with due respects to everyone, every inhabitant of the society, I must say that we are a hypocritic, we are a hypocritic lot. That we say something when it happens. We all go to theatre, our condolences to the victim who suffers a particular, offence. But when it's over, we all forget everything. I mean, I just want to ask that, what does it take for the Ministry of Information and Broadcasting to come up at least with an advisory, if not an order, to the picture hall owners or the cinema hall owners to run a 2-minute clipping on the importance of women before a start of a movie?
Okay, you're talking about awareness that is required in our country. We'll come to that as well. But I want to come to Mr. Hegde on what the last caller had said about I fear the lynch mob mentality in the country and taking law in your own hand for getting justice.
Oh, let's have a public hanging for rape cases. Let's have a public hanging for dowry cases. Let's have a public hanging for maybe scheduled caste cases. It will go on and on. We are now a country led by a constitution, and we are a government of laws. Quite some time ago, there was an order from the Rajasthan High Court that in a dowry case, that the mother-in-law should be hanged at the Savai Madhav Singh Stadium. In a case called Attorney General versus Lakshma Devi, the Supreme Court said, look, this is just not on. We are bound by a constitution. We protect the right to life, and the right to life includes the right to dignity of even the worst kind of prisoner.
While you bring that to light, I want to come back to the larger debate of what are the legal problems which we will face if there is to be an amendment into this particular law, because like you pointed out, the WCD is also looking at it at the moment. What are those legal hurdles that can come in changing the age of juveniles?
No, it's very easy to pass a law. But once you start implementing it, I see the same kind of chaos ahead that for instance, the overuse of 498A of the Indian Penal Code, which relates to cruelty. Just 1 minute. Just hang on for him. Which has brought about so many changes in families and in divorce laws. Now, for instance, just take the example of what happened a few years ago with the DPS Juvenile. Who made an MMS of a particular sexual act. Now, if the law of rape has changed, as it has now been changed in 2013, and then you also criminalize juvenile rape, then that particular adolescent would have been tried as an adult, and it's the same issue. After Tejpal.
Okay, 1 second. We're slightly digressing.
I'm not. Just let me see. Teenagers are going to experiment. Teenagers are going to get physical.
Right.
Now, if you make everything criminal, you are effectively going to criminalize a lot of our teenage population.
Sir, you are trying to say...
if the teenagers
sir,
are listening
you are trying to say, please,
no,
I'm sorry to intervene, but you are trying to say that they should be allowed to experiment by raping someone and
not by raping.
I will come to you. I will come to both of you.
I'm sorry, I do not buy that argument.
I will come to the rebuttal in just a bit. Before that, I just want to listen to what the callers have to say meanwhile on what you have said, Mr. Hegde. We have Brijesh Roy from Gwalior and Shri Prakash from Orissa. Shri Prakash, please stay with me. Brijesh Roy, kindly go ahead.
Sir, I have a very simple suggestion to make.
Okay.
Can we extend the amount of punishment for juvenile from 3 years to 10 years? Is it possible? I think that will be the better option.
Okay. All right. You think extension of punishment should be granted. Thank you very much, Brijesh. Shri Prakash from Orissa, kindly go ahead.
For the intensity of the crime committed, it should not be bracketed that is 16 to 18 years or 14 to 16 years. The juveniles are not juveniles. Their mindset has changed. They are committing such crimes. So there should not be any age bar for punishment. Intensity of crime should be the only criteria.
Okay. Thank you very much, Shri Prakash. Sangeeta joining us from Mumbai. Please go ahead. Express yourself. Sangeeta.
My very one point is, juvenile being juvenile, if they can do the act, why do not they deserve a punishment which an adult is doing, an act which they have gone and committed. Damini died because of that juvenile final drastic act, and the anger is terrible on the part of an adult, whether it's a juvenile. We question the fact, why should he not be punished? They deserve strong punishment.
All right, Ms. Sangeeta.
198A needs to be looked into deeply.
All right, Ms. Sangeeta, thank you very much. Anuradha from Chennai, please go ahead, speak your mind out.
In countries like France, even if the juvenile commits a rape, the imprisonment is 20 years.
Yes.
In fact, even for an adult, it's only up to 15 years. But if it is a same crime, if a juvenile does it, it's for 20 years. So there's no difference. In fact, they want to make it as a deterrent that even at such a young age, they've got the audacity to go ahead with such a crime. So they've increased it to 20 years. And China gives the capital punishment for rape. Afghanistan, capital punishment.
Well, it's not just rape that we are referring to. We're actually discussing the act the juveniles conduct. And talking about the acts, I want to bring in my colleague Ritangshu now, who will take us through the rise in crime graph where juveniles are concerned in terms of rape and murder. Ritangshu, take us through those details, please.
That's right, Akshay. For those who believe that juveniles always have a potential for reform, let's have a look at some of the statistics which we pulled up from the National Crime Records Bureau. These are cases of the number of rape and murder cases committed by juveniles in these 3 years. In 2009, the number of rapes committed by juveniles rose from 858 to a whopping 1149 in 2011. And then in 2012, it rose further to 1175, and what our records are telling us that this year it's even more. It's also equally disturbing when it comes to murder cases. From 679, it rose sharply to 888 in 2011, and then even more to 990 in 2012. Back to you, Akshay.
Ritangshu, thanks very much. Shocking statistics that have come forward. And before I come to you, Mr. Hegde, just a quick check with Dushyant Singh from Noida and Dr. Nagesh from Hyderabad. Dushyant Singh, please stay with me. Dr. Nagesh, please go ahead.
Yeah, I have a feeling that the law, whatever is made on these youngsters, is a very old law, and there is every need to change the law at any cost. Because as a psychologist, I can tell you, the people who are in teenage, they are very selfish by nature. They want to do some adventure. They do not want to care anybody, and they really want to go on the negative side as far as the present conditions of the life are concerned. So there is every need for the lawmakers to make a new law saying that even youngsters can be punished as adults when they commit such heinous crimes.
All right, Dr. Nagesh, thanks very much. Yes, I'm just coming to you, last caller for the time being. Dushyant Singh from Noida, please go ahead.
I just want to make a simple point here. Since this heinous crime has been done, since it's almost a year now, we are talking about this one juvenile here. Now, I fail to understand when we have our whole belief in the judiciary of India. When it comes to juvenile, why we just do not trust the judges there? They know the crime, what kind of crime has been done?
No, it's about the provisions of the Juvenile Justice Act that are being questioned at the moment. It's not about the judiciary so much. It's about the law. And then I'm going to take this forward to Ms. Masoodi at the moment, who wanted to interject and revert to what Mr. Hegde had said. Go ahead, ma'am.
It's 33,000 minors who have been arrested in the year 2011 which has been the highest so far in a decade, that have been arrested for murder or rape. Now, as Mr. Hegde had said just a moment before, he gave a reference to 498 cases. Let me emphasize that Honorable Supreme Court is of the view and holds very firmly that misuse of any particular provision of law does not qualify it to be declared as ultra-virus. Having said that, I must say that this is the high time where we do not only have to change a particular provision of the Juvenile Justice Act, but the entire overhauling of Juvenile Justice Act is required.
Okay.
We all need to understand that which are the important areas where the chunk of vulnerable children live, how to tackle the entire problem, how to sort it out, how to develop a mechanism, for the simple reason that the purpose of the law is not in its enactment. It is actually in its implementation to make it more meaningful.
I'm going to take that forward in just a bit. Before that, I want to go across to two callers, and Mr. Amod Kant has been waiting for a while. Sir, I'm coming to you. Stay with me. Nitin Singh from Chennai and Rekha from Mayur Vihar, Delhi. Rekha, stay with me. Mr. Singh, please go ahead.
It's not in its enactment. It is actually...
Just reduce the volume of your television, said Mr. Singh. There's a lot of feedback, echo that's coming in. Reduce the volume and start speaking. We can hear you.
Ready for a while. Sir, I'm coming to you. Stay with me. Nitin Singh from
Okay, we'll connect back with Mr. Singh in just a bit. Rekha Dubey from Delhi, please go ahead, ma'am.
Yes, sir. I would like to share my thought with you, and I think it is very important. I just asked a question to each and everybody, sir.
Yes.
I just asked if adult law is made for making crime, or adult law is made to give all the rights as an Indian person. It's just as simple as after getting 18 years of age, each and every Indian gets all the rights. Moving here, doing good things, whatever is wants in life, right? But it doesn't mean anywhere that he is allowed to do rape, murder, or any kind of such crime. It may be initiated by other people, and they can use children also for their own purpose.
All right, Rekha. I'll have to move ahead. I have to go across to other people as well. Thank you very much for calling in. Mr. Kant, I want to begin by asking you, isn't it miscarriage of sorts for justice of victims of murder and rape when we see juveniles get away with just maximum of 3 years of punishment, which is not even a punishment, which is a remand home?
See, the age, there has to be a dividing line. Because so far as leaving kind of the decision to any body, any legal body also, saying that depending on the maturity or depending on the gravity of an offence, you decide. It's a very subjective and personalized kind of situation. World over there is an age. In India also, let me clarify that the immunity to a crime is given only up to 7 years of age. Beyond 7 to 13, 12 years of age, there is no immunity. It depends on the maturity or the understanding. If the court or juvenile justice board is of the opinion that a particular child is able to understand whatever the child has done, then that starts accordingly. I mean,
stay with me on that thought. Stay with me on that thought, sir. I'm coming back to you. Mr. Hegde, I also want to understand and move a little ahead when we talk about the entire changes that is required, even if this change is brought about where the age is reduced or exceptions are made. I want to understand from you, in your view, do you think the crime graph of juveniles committing rape or perhaps murder is going to come down in the country?
Look, crime graphs go up with the population rates. That statistic, while interesting, was misleading because you do not compare it against the general crime graph. What is it? The crime, there will be a similar rise in adult crime also. That is, so to have a correct apples to apples comparison, you have to see the rise in crime rates all over.
But yet you will agree it is worrying. But yet you will agree it is worrying to see juveniles getting into such.
If we do not nip this problem in the bud, we are going to produce more criminals.
It is worrying. And what is more worrying is that adults will be misusing juveniles. Now, this particular Damini case, let's take the Damini case itself. I doubt that the juvenile on his own would have got into that situation at all. It was when he was in a situation with 5 other adults,
no, but that has a choice. That 17-and-a-half-year-old has a choice of deciding what's right or wrong.
He would have jumped out of the bus.
So that's the choice that 17-and-a-half-year-old made.
That's a different point. That's a different point. Now the question is, for a choice that a juvenile makes, whether he's 17-and-a-half or now if you lower the age to 16, if he's 15-and-a-half, does a juvenile make the same choice that somebody who is an adult makes? The law presumes no, not only for criminal law, but for civil law as well.
Okay.
In civil law, for instance, why is it that we don't allow people below the age of 18 to enter into a competent contract?
Because I will come to you, ma'am. I will come to you. Let's
the assumption in law is that it's only after you turn 18 that you are fully competent to take on all the rights and all the liabilities.
Okay, hold that thought. Balachandra from Bangalore and Kishore from Pune. Kishore, stay with me. Balachandra, please go ahead.
Yeah, good evening.
Good evening, sir.
Yeah, I have a question. Actually, it's a shame. You know, whether a person is 17 years or 18 years, once a crime is committed, nobody thinks about the agony of the family members, number one. Number two, I have a question to our panelists who support journalists. Assume that the heinous crime of Mumbai, 26/11, was committed by five people below the age of 18.
Out of which 3 were minors. Yes, we will come to that also in just a bit. Kishore from Pune, please go ahead, express yourself.
Sir, 2 questions. Number one, with all due respect to that person who is talking about Juvenile Justice Act. It is not a Juvenile Justice Act, it is a Juvenile Rehabilitation and Justice Act. But in that, it's only talk about rehabilitation of people, of the kids who are on the road and this and that and who have nobody to be taken care. It doesn't talk about the crime of that juvenile. Second question, if we are talking about the laws, right? The Juvenile Justice Act, the criminals. Well, see, the 18 age was decided when...
Okay, Kishore, the point is there are many questions and a lot of viewers want to ask questions to our panelists, but unfortunately we're out of time. Ms. Masoodi, 10 seconds you have to wrap up for us, sum it up for us. Can this go ahead?
Akshay, yes, I would emphasize on the fact and I would disregard, with due respects to Mr. Hegde, I would really disregard his kind of, leniency towards juveniles, indulging into heinous crimes.
Ma'am, briefly, we have to wrap up.
By saying so, I must say that when the pain, when the agony doesn't change on the victim, whether she is being molested, raped or assaulted by a major, when it doesn't change the kind of pain she suffers, then how should we bother about that what is the age and what is not the age of the offender?
I think we'll have to sum it up with that. We're in an evolving society. Laws need to evolve and we need to bring about some change where deterrents are set. And we'll have to leave it at that.
Deterrents have to be set.
Mr. Hegde, Ms. Masoodi and Mr. Kant and all the callers, thank you very much. I'm afraid we're out of time, but that's all we have for you on Speak Out India. Good night.